For many who come to the United States, their dream is to become a US citizen. Here at Scott Legal, we know the ins and outs of navigating the path to citizenship in the United States. So, how can a non-citizen become a citizen of the United States? There are two typical sources of US citizenship. The first is birthright citizenship, meaning that the person qualifies for citizenship either by being born in the US territory, or by being born abroad to one or two US citizen parents. Or, a person can qualify for citizenship through the naturalization process. This requires them to become a legal permanent resident of the United States, and to meet continuous residence and physical presence requirements. The U.S. Citizenship and Immigration Services, USCIS, oversees the naturalization process. Let's first look at birthright citizenship, or those who automatically receive citizenship at birth. Under the U.S. Constitution, a person who is born in the United States, and subject to its jurisdiction, is automatically a U.S. citizen. Automatic citizenship at birth may also occur when the child is born to one or more U.S. citizens abroad. At least one of the two parents must have been physically present in the U.S. prior to the child's birth. The required length of physical presence, as well as several additional requirements, depends on whether the parents were married, and whether the father or mother was a U.S. citizen at the time of the child's birth. Certain children under the age of 18 who did not automatically receive citizenship at birth, but who have one or more U.S. citizen parents, may be eligible for citizenship or naturalization. These provisions are found in Sections 320 and 322 of the Immigration and Nationality Act. Naturalization is the process by which a non-citizen, who is a legal permanent resident of the United States, applies for citizenship. To qualify, the permanent resident must satisfy the residency requirement. This means that the permanent resident must maintain lawful permanent resident status in the United States for 5 years. If the permanent resident is married to a U.S. citizen, the residency requirement is only 3 years. The permanent resident must also satisfy the physical presence requirement. This means that, depending on the length of the residency requirement, the permanent resident must have been physically present in the U.S. for 30 months out of the 5-year residency requirement, or for 18 months out of the 3-year residency requirement. The permanent resident must also establish good moral character throughout the residency requirement. Finally, the permanent resident must have lived for at least 3 months in the state where she has a primary residence. There are also restrictions on the length of time the permanent resident is allowed to be outside the United States. Travel abroad of less than 6 months will generally not disqualify a permanent resident from naturalizing. However, an extended stay outside of the United States of 6 months or more may disrupt the period of continuous residence. Continuous residence will be automatically disrupted if the permanent resident stays outside the U.S. for 1 year or longer. In this case, the permanent resident's continuous residence clock will restart. Fortunately, an absence from the United States of more than 6 months, but less than 1 year, does not automatically disqualify the permanent resident from naturalization. The permanent resident would have the opportunity to convince USCIS that continuous residence was not disrupted, by showing one or more of the following. That her employment in the United States was not terminated. That she did not become employed outside the United States. That her immediate family members remained in the United States. Or that she continued to own or lease a home in the United States. Certain past conduct during the 3 or 5 year residency period will disqualify a permanent resident from being able to file a naturalization application. Such conduct includes not meeting income tax obligations, not meeting child support obligations, not meeting the physical presence or continuous residence requirements, and certain criminal convictions. All permanent residents applying for citizenship will need to file Form N-400 with USCIS, along with a required filing fee. Once USCIS receives the application, they will schedule dates for fingerprinting and an interview with a USCIS officer. At the interview, the officer will examine the application to confirm eligibility. The officer will also administer a citizenship test that asks about U.S. history, government, and law. The permanent resident must answer 60% of the questions correctly in order to pass. The questions are selected from a total of 128 questions that are available online for review. Certain exemptions to the testing requirements are available for those who have a physical or mental impairment, and for those who meet certain age and residency requirements. If the permanent resident passes the test and meets the officer's approval, they will be invited to the oath ceremony. There, they will pledge allegiance to the United States, thus becoming a U.S. citizen. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you. You can also schedule a consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.